Today I'm going to talk about blood and urine tests, especially with respect to DWI cases. You might think that if you gave a blood or urine sample after a DWI arrest, that if the result comes back at a .08 or more, that you must be guilty and it's not even worth challenging. But that's not right. We've had a lot of cases where we've actually had samples retested by an independent lab, and lo and behold, those results have come back under a .08 or under a .20, whatever the relevant part is. That can make a huge difference because it can lead to your DWI getting dismissed or the charges being lowered in your case. And it can also mean that your revocation times for how long you're revoked under the implied consent law can go way down or even be undone, and you might be able to avoid being revoked at all for a DWI. So today I'm going to talk a little bit about what things can go wrong in blood and urine testing and what some potential challenges are. Alright, so after you're arrested for a DWI, the officer, if they don't ask you to take an intoxilizer test, they'll ask you to give a blood or urine sample. First of all, you've got the right to reject one and then take the other. So if they ask you for a blood sample and you're afraid of needles, you can say no thank you, and then they have to offer you a urine test. Otherwise, they can't charge you with a refusal. If they offer you for a urine sample and you'd rather give blood because you think that's more accurate or something, then you can elect to give a blood draw. In either case, you also have the right to consult with a lawyer if you can get a hold of one in time before you make that decision. All right, well, when you give your sample, there's important things that we look at as lawyers to determine whether or not we can attack the validity or integrity of that sample. And sometimes we can keep test results out before a case ever even goes to trial. And another thing we can do, and in that case, then the jury never hears that you even took one of those tests or that you were over the limit, and that's important. And then in the other example, if the test doesn't keep out, we can still cause reasonable doubt as to whether or not the test is reliable, especially if we have a good retest that suggests that the first test wasn't done properly. So the first thing we look at is whether the officer followed the correct protocol when requesting that you give a sample. And those are things like, was the environment sterile? Was the container, whether that's the two blood vials they use or the cup for the urine, was that tampered with in any way, or was it unsealed, was it expired, things like that. Second, we look at whether or not there was an anticoagulant powder in the blood example and the preservative in the blood vials as well as the urine cup. Third, we look at again whether there was a sterile environment at the time that your sample was taken, either when you were urinating or if the nurse or phlebotomist or EMT properly swabbed your arm with the right material and whether that was done at the right time. There are actual collection procedures that have to be followed, and if those procedures aren't followed the correct way, that can compromise the integrity of a test. And then when the sample is collected, certain things have to be done. It has to be sealed the right way. It has to be mixed with the preservative and the anticoagulant the right way. Generally, you're supposed to seal the samples, and that's supposed to be initial the samples, and that's supposed to be done right in your presence while it's sealed. And then we deal with chain of custody. What happens to the sample after it's all sealed up? Did the officer care for it in the right way by refrigerating or freezing it, or making sure that the protocol was followed the correct way there? The next question is then, how does it get to the crime lab where it's ultimately tested, and was that all done the right way? And then once it gets to the crime lab, number one, was the chain of custody followed? If the government can't show that there's a proper chain of custody for a sample and bring forward everybody that ever had their hands on this sample, that can lead to a test not being admissible against you, which is a great thing for your case. Also then, of course, we get into the testing method. Did the BCA analyst test the sample the right way? Were there any flaws in that? Was there any storage problems? Was there any contamination? Did they see anything wrong with the sample itself? We have a forensic toxicologist look at those samples to determine whether or not, or the reports rather, to determine whether or not there are any errors on the face of the report. And then what we like to do is, of course, make sure the sample is preserved. And oftentimes we'll get a retest of a sample by an independent lab to determine whether or not the sample that was tested that accuses you of being over a .08 or over a .20 is valid. And like I said, a lot of times these retests come back lower. That's important because if all the protocol was followed by the crime lab, then there's no reason that the blood alcohol level should dip in your urine or blood sample. In other words, because there's a preservative in there, and if all the other protocol is followed right, that result shouldn't change. So if there is a difference at an independent lab testing and they've followed their protocol the right way, then why should the crime lab's result be any more believable than an independent lab's result, especially when the independent lab is an approved lab by the crime lab. And those are a lot of the challenges, just short examples of the challenges that we can make to blood and urine testing. These can make a large difference in your case and give you a better outcome. If you have any other questions, my name is Ryan Pacyga. You can call me at 612-339-5844 or visit my website at www.arrestedminnesota.com. That's www.arrestedmn.com.